Welcome to our study today. Our study looks at the Nasciturus doctrine in South Africa's law. We have other videos that look at the commencement of legal subjectivity in South African law, and this time around we are looking at the Nasciturus doctrine and whether it is relevant in South Africa's law. You will remember that only legal subjects have legal capacity as bearers of rights and duties. Because a legal subject is a bearer of rights and duties at law, therefore it is only legal subjects, legal persons who are bearers of these rights and duties at law. Legal subjects consist of natural persons as well as juristic persons. When we talk about natural persons, we are talking about human beings, flesh and blood, like myself and yourself. But when we talk about juristic persons, we are talking about entities that are created at law, maybe for the purposes of gain. Could be a club, it could be a company or a government department. So it's actually a juristic entity in the sense that it has an existence separate from the members that constitute it, as I have given you examples of clubs and companies and so on. Now you'll notice that Roman law protected the rights of legal subjects, particularly the fetus, through the doctrine expressed by the maxim, the Nasciturus pro gem noto. That's Latin for you. You can go ahead and read it as it is expressed there. And so it is very important to us understand that a fetus is neither a legal subject nor a bearer of rights and duties enforceable in the court of law. So it is only through this fiction, the Nasciturus fiction, that the Roman law protected it. Still on the issue of the Nasciturus fiction and its applicability to South African law, I would like to begin by looking at whether in fact, what a Nasciturus doctrine itself is. We have a doctrine which says an unborn child, what is sometimes called a child in utero or a fetus, subsequently born alive, will acquire all the rights of the born children whenever it is to its advantage to do so. Can I take it again? An unborn child subsequently born alive will acquire all the rights of the born children whenever it is to its advantage. In other words, it may be a uterus, so it may be a fetus in the uterus, but if there are any rights that would accrue to a human being or a child, then this fetus is also entitled to those rights, provided that it's going to be born alive. So we are saying it is expressed as follows: if the Nasciturus, that is the fetus, if the Nasciturus would have had claims or rights had it already been born and alive, the rights or the claims are kept in abeyance until it is subsequently born alive, when it acquires legal personality. So this right, the rights in terms of the Nasciturus fiction are actually expressed in terms of the Nasciturus rule or a Nasciturus fiction. As we proceed further in the discussion, we will highlight the distinction between the Nasciturus rule and the Nasciturus fiction. The Nasciturus fiction was best expressed, in fact, by Judge Heemstra in the Pension vs. Santam Insurance case in 1963, where he said, "I hold that a child does have an action to recover damages for prenatal injuries," and says This rule is based on the rule of the Roman law received into our law that an unborn child, if subsequently born alive, is deemed to have all the rights of a born child whenever this is to its advantage. There is apparently no reason to limit this rule to the law of property and to exclude it from the law of delict. So you find that this pinching case has been very paradigmatic in terms of the incorporation of this Nasciturus rule into South African law. But as we proceed further, we will see how it was first expounded in 1909. We'll look at the case as we proceed. Now we said that the Nasciturus doctrine is expressed as a rule and as a fiction. Now, in terms of the Nasciturus fiction, legal subjectivity only begins at birth, but rights are held at bay pending a successful birth. In other words, rights are held on behalf of an unborn fetus, provided that is going to eventually be born alive. Then those rights can begin to be imputed upon the fetus. But if it does not eventually get to be born alive, then those rights fall away. Now, in terms of the Nasciturus rule, legal subjectivity begins at conception, and if there is a benefit which could accrue to the fetus once it is born, allowing it to receive rights prior to its birth. So you see, in terms of the rule, there is a predating here of legal personality and legal subjectivity, whereby it is assumed that the fetus is already born, it has all the rights, and then if it is eventually born alive, it will begin to exercise them, but they were not they don't arise at birth. The rights have always been there since conception. So that's what the Nasciturus rule holds. Now, you notice that predating legal subjectivity to conception raises a legion of practical problems, since abortion would then be deemed a violation of the rights of another legal subject. So if, for instance, we assumed that at conception the fetus becomes a legal person, then it would mean that abortion would be the same as murder. It would be equal to murder, since termination of a pregnancy would violate Section 11 of the Constitution of the Republic of South Africa of 1996. This matter was entertained in the Christian lawyers case, Christian Lawyers Against Minister of Health, in 1998, where it was considered that if legal subjectivity were to be predated to include right to the point of conception, then the word everyone has a right to life, as espoused in Section 11 of the Constitution, would mean that abortion would be a violation of the law. It would actually be tantamount to murder. And it would also become very difficult to put to effect Section 12(2)(a) of the Constitution of the Republic of South Africa, which enshrines the rights of women to bodily integrity, as well as to make decisions based about their reproductive health. So the practical challenges anticipated in the Christian Lawyers versus Minister of Health case of 1998 actually highlight some of the challenges that would appear and be the main issues if really legal subjectivity were to be predated to the time of conception. Now, there are certain requirements to be met in order for the doctrine to become operative. A right must have accrued while the newly born was a fetus. Remember, we are saying that these rights are only enforceable after birth or at birth. So we are saying a right must have accrued while the child enforcing the rights was still a fetus. And well, we are saying that it goes without saying that from that fetus stage, the child must subsequently have been born alive, and then the birth must have been fully completed, implying that there must be a complete separation between the body of the mother and the fetus. And then we are saying after separation, the child must have lived independently of the mother, even if for a short period, evidenced by the ability to breathe independently, either naturally or with the aid of a ventilator after separating from its mother. That is when the child is separated from his mother. And then the action is for the benefit of the fetus, that is the child born who was a fetus at the time of the occurrence of the act or omission, whatever is relevant as a cause for action. So we are saying the action is for the benefit of the fetus and not another party. As you would notice in the case of wrongful life and wrongful birth actions, which must be prosecuted in alternative. We are saying that it is for the benefit of the child that these rights are kept in abeyance, not for the benefit of a third party. So there's a debate on whether the Nasciturus doctrine or the Nasciturus fiction is a principle of South African law. Well, as I indicated earlier, it was received into South Africa's legal system and first applied in the Chilsom versus East Rand case in 1909. In this case, the Chilsom versus East Rand, it was an issue of the rights of action for maintenance by a child whose father was negligently, whose father had died through the negligence of another. So against the person who culpably caused its father's death, it was held that the child had a right of action, that is to seek support. That's parental support we are talking about. Now, this fiction was later applied in the ex parte Boedel Steenkamp case, which was dealing with the issue of tested inheritance by a child born after the death of the testator. That's the person who had drawn the will, who happened in this case to have been its grandfather. And then you find that it was also applied in the Pinchin versus Santam insurance case, very paradigmatic, paradigmatic, like I said earlier, where it dealt with the issue of the rights of insurance, delictual action for injuries sustained while one was still a fetus. So that's very, very important to think about these issues. Its applicability at law, there are quite a number of questions. Is it applicable at South African law, and to what extent? In terms of in the issues of parental support, yes, it was applied in the Chisholm rather versus Eastrand Property Mines Limited in 1909, and then it has also been applied in matters of cases of status to determine a person's status at law, that is the status of a fetus. And then the ex parte Boedel Steenkamp case dealt with it dealt with inheritance. So we are saying the Nasciturus fiction may be applied to protect rights of children conceived posthumously. Some people have been opining that it might now be relevant in respect of children born posthumously, maybe as a result of in vitro fertilization and cryogenic preservation of the male and the female gametes. where you find that because of advances in medical science, some male and female gametes can now be fertilized outside the human body and be, preserved in laboratories and then be inseminated into a surrogate mother later on in life. So some people are saying that the Nasciturus fiction should be applicable under such circumstances. And then, of course, there are issues of criminal law to do with abortion. In the S versus Mango case in 1980, it was held that it was actually applied. The debate was about the abortion, and then it also came up in the S versus Mashumpa and other. This Mashumpa was accused of killing a fetus, so there was an argument whether a verdict, first a charge of murder, then a competent verdict of murder would be appropriate in the case of killing a fetus. And then the court found that extending the Nasciturus fiction to a murder case and perceiving a fetus as a child would actually not be in line with the definition of the crime of murder according to the common law, as well as the definitional elements of the crime of murder and the definition of the crime itself. Now, one of the areas where it has been applied, of course, is the area of delict. We've spoken already about the Pinchin and another versus Santam Insurance Company Limited in 1963. And there's also been the Road Accident Fund versus Mtati as recently as 2005. But the interesting outcome of the Mtati case, and even the reasoning, is that maybe it was not even necessary to invoke the Nasciturus fiction, because apparently it could still have been possible, it is still arguably possible to deal with intellectual issues without having to refer to the issues of the Nasciturus fiction doctrine. So there's an opinion that basing intellectual claims on the Nasciturus fiction is not necessary, because ordinary principles of the law of delict are sufficient to, cover the interests of the unborn. And then there's also the issue of whether life can be an injury. The issues of wrongful birth and wrongful life, which have become very prevalent and also, one would say, very, very common in recent years. In the Friedman versus Glicksman case in 1996, the issue of wrongful birth by parents blaming, in fact, taking action against the medical practitioner for improper advice leading to a disabled child being born. The same was done in the Stewart versus Botha case, where the rights of an unborn were actually in question, and the parents were opining that they could, if they had been, given sufficient information, they would have aborted their pregnancies. Now, there's also the issue of wrongful life, where Kingsbury versus Kingsbury's Fetal Assessment Center has been one of those leading cases in 2015, where the court was made to decide whether life as a disabled person is inferior to being not born at all. In other words, the court was being asked to determine whether it is better not to be born at all or to be born with disabilities, or vice versa, which one is better. So, and the court there declined to make such a judgment, opining and concluding that this would amount to delving into metaphysics and philosophy, which the court was not in a position to do. So those are some of the very critical issues that are relevant to these kind of discussions. Issues of wrongful birth, as highlighted above, have actually been very critical, raised from time to time, and courts have refused to award such actions on public policy grounds. In Stewart versus Botha, the question was whether a life with disability is worse than not being born. Can a court answer such a question without people living with disabilities feeling that their lives are inferior to those of others? Because this is one of the challenges. It's actually making a value judgment on whether it is better not to be born or to be born with disabilities. And then the value of the Nasciturus fiction in respect of wrongful birth and wrongful life actions in South Africa is almost non-existent. It has not really been accepted as an important or a decisive principle, if one could call it that. The question is, does the Nasciturus fiction have any place in South African law? The Road Accident Fund versus Mtati case in 2005, on pages 13 and 14, the judgment demonstrates that these issues of prenatal injuries can actually be decided and determined without having to revert to the Nasciturus fiction. This echoes the views of Professor Joubert, who is of the view that the application of the fiction in the Chisholm versus Eastrand Proprietary Mines Limited in 1999 was actually misplaced. Professor W.A. Joubert, in a note on the Pinchin case published in 1963, actually gave an opinion that the application of the Nasciturus fiction had not been necessary as the solutions could have been obtained by applying the ordinary rules of the law of delict. So according to Joubert, there has not been a need for South Africa to incorporate the Nasciturus doctrine into its law as a principle, because he feels that there are enough principles within the law of delict itself that can be developed to cover all issues where there is a prenatal or pre-birth injury. So that's the issue, which then renders the application of the Nasciturus fiction a very controversial thing, if one could say, in South African law. Now, in conclusion, we notice that the Nasciturus fiction was received into South African law and has been used in various situations. Among them, there are issues of inheritance, where we are saying inheritance has been extended to persons by holding rights in abeyance pending a complete or successful birth. Then we are saying in case of injuries inflicted on a fetus, that is pre-birth injuries, have been recognized as the basis for the claims. And then the court in the Road Accident Fund versus Mtati case noted that the Nasciturus fiction was not a prerequisite for a successful claim based on prenatal injuries. The court actually said in the Mtati case that these cases, some of these issues could still be decided without necessarily reverting to this Nasciturus fiction. And in the Mashumpa case, Meda, it was clear that Meda is not a competent charge or verdict in connection with the destruction of a fetus, and the Nasciturus fiction was not applicable here. So the value of this fiction, of the Nasciturus fiction and the Nasciturus doctrine generally, in respect of wrongful and wrongful birth and wrongful life actions in South Africa, is non-existent. Thank you very much for being part of this presentation. I hope it has benefited you. Looking forward to meeting you next time. Enjoy your day.